so cold in this room.
God, it's so cold in here, I can't believe it.
Yeah, I went to get tea. I got myself some tea because it's warm off. Do we have our own thermostat? We don't, right? No.
A thermostat? I don't know. It didn't even occur to me to look for one.
No,
I'm used to it being locked and not being able to touch it in a building like this, you know?
No, it doesn't. I don't even know what that is. It's
Can't
an
get to
alarm.
it? That ain't it?
No, it's an alarm. And then this is for that overhead.
Yeah, that switches for that, right? Yeah.
So I have a question for you.
Yeah.
What did you do during the crash when the market was slow, when things weren't working out? What did people do? I'm afraid of going through a phase where there's no employment, or where employment is, you know, where business is low, because crashes happen. They're cyclical, right? So.
Oh yeah, yeah, it'll happen again.
Right.
You just tough it out. I don't have a good answer for you, but I think it affected just about every business.
It did.
So I don't think it's a matter of staying away from real estate because real estate took a dive. Everything took a dive. You know, this wasn't just a real estate recession. This was a national recession. You know, so I don't have a good answer for you. I mean, a lot of title companies closed up.
Yeah.
A lot of real estate firms shut down.
Even banks.
Banks, you're right. Banks have had more of those closing crashes in the past than other industries.
Car dealers, even GM had to be rescued. I mean, everybody.
Yeah, no, I don't have a good answer for you, Laura. I don't think, candidly, about the only field that I see that doesn't have is medicine. And yet some things in medicine even suffered because a lot of non-essential stuff didn't happen.
What about technology?
I'm sorry? About what?
Technology.
That should be booming, but you know, people just quit hiring everywhere because they weren't sure what the future was going to be, so they quit with new hires. But I agree with you. That's obviously better. You know, law enforcement is pretty safe because the governments didn't cut back their budgets much, and
That's where I was.
education.
Yeah?
You know,
Oh, you were
but
in the military too?
traditionally, education and law enforcement and working for governments were lower paid end of the scale anyway, and people didn't want to be there, you know. They wanted to be where they could make the big bucks in the good times, and in the bad times they had to suffer the consequences. I don't have a good answer for you of what was a safe thing in real estate during the recession. I don't know that there was, except we used to joke about the only people who were still doing deals were governments because they had cash.
Yeah,
Even when you couldn't borrow and couldn't get loans, governments were doing deals because they have tax revenues, they have cash, they can, you know, buy and develop, and so it's certainly not recession-proof. Okay, Chapter 11 talked about all the different things that could be in a real estate contract. I want to run through their discussion of them and relate it as best I can to what we've done, and talk about the handful of other concepts that we didn't touch on. According to the list in the book, the first thing about a contract is a date. That's going to take care of itself. We talked, you know, parties are going to date their signatures. We talked about what I think is more important, which is the effective date, which is the date from which time periods are measured. But a contract's going to have a date. The second thing the materials talk about is the parties, and that is the first of what I call the big three: getting the parties named correctly, the buyer and the seller. If they're entities, getting their names right. Normally, a contract, when you have an entity, talks about what kind of entity it is. In other words, go ahead and say XYZ Corp., a Florida corporation, a Florida limited partnership, a Delaware corporation, or a lot of the big corporations. Say what type of entity it is you're dealing with. When you name an entity, with individuals, make sure you get them all. Make sure you get their names right. Property description is the second of the big three. The courts say to describe property with such provision, with such precision, I apologize, that a surveyor can locate the property. We're going to talk about surveys in another chapter when we get into legal descriptions, but you always want to have a legal description. There's nothing wrong with doing a street address in addition, because that helps the parties tie what they have seen and what they think they've viewed as the premises being described, as the property being described in the contract. But then you want to go find the legal description. There are a couple of ways to do that. If you can get a copy of the seller's deed, you want to get it from there. If not, you go to the property appraiser's website. We're going to talk about that in our deeds chapter. I'm going to actually go through with you a property appraiser's printout, which is the Broward Property Appraiser has a file on every single piece of property in Broward County, by owner, by legal description, by description of improvements. Take the legal description from there if you can't get it anywhere else. As you'll see when we see it there, you go to the Broward County Property Appraiser's website, bcpa.org or something like that. And one of the selections is called Property Search. And you can search for a piece of property there by its street address or by the names of the owner. And either way will lead you to their page for that piece of property. And that page will give you the legal description.
And Dade also has that too.
Cool. Most counties do. Yeah. Almost everybody's online now. Okay. Price. I've never seen a sales contract that didn't have a price. I've never seen the parties leave it out. In my opinion, parties pay too much attention to the price, and that's about all else they think about. But you're not going to miss it, and you're never going to see a form that doesn't have a blank for the price. It pretty much takes care of itself in terms of being something that nobody's going to forget to make sure is in the contract. That's the gross total selling price of the property. And then as you saw in our form, you break that down into deposit, type of financing, of how's it going to be paid, etc. But the price is the price. The total purchase price of the property. Contingencies. The book talks about there being different types of contingencies. As we saw, a contingency is something that is a condition that says that something has to occur in order for there to be a closing. And it's something that must occur after the contract has been signed, but prior to closing. Common contingencies are financing, the buyer's ability to get approved for a loan, inspections, buyer's inspections being satisfactory, appraisal. Parties often put in the contract an appraisal contingency that the property must appraise for whether it's the purchase price or whether it's 98% of the purchase price, but a condition of something that must occur later in order for performance to be required under the contract. That's a contingency. Possession. Contract's always going to talk about possession, when, will the seller deliver possession to the buyer? And there are really three things that can happen there. Normally, it's at closing. At the time of the closing and the transfer of title and the payment of the money, possession passes from the seller to the buyer, normally with the transfer of keys and security alarm codes and stuff like that. The contract may provide that possession will occur prior to closing. Sometimes the seller, if the seller's already out of the property, will allow the buyer into possession before closing. It's not a good idea for either side. Particularly, it's not a good idea for the seller for two reasons. Number one, it lets the buyer spend a month or two on the property and find out things that are wrong with it. It might make him change his mind and decide not to close. So it could hurt your deal. And secondly, if something goes wrong in the deal, it can be hard to get the buyer out of there. Seller wants to start showing, if the deal's dead, the seller wants to start showing the property again and sell it again to somebody else, but not with a buyer in there. Sometimes you might have to file suit and have a judge order them out and have the sheriff throw them out. So it's really kind of a bad idea to have possession prior to closing. And sometimes possession is after closing. Sometimes the seller insists that the seller gets to stay in possession for a couple of months after the closing. His other house isn't ready, not ready to move, or doesn't want to move until he knows he's had a closing. That can be a problem for the buyer. Same problem. Buyer now owns the property, has paid the money, seller won't get out. What are you going to do? Might have to sue. So there's a reason why possession normally takes place at closing, at payment of the funds, because it presents risks for both parties to do otherwise. Best by a long shot. Posture for both parties is that possession pass at the time of closing. Okay, prior to closing, the contract is going to talk about the seller giving evidence of title. The seller has got to show the buyer that the seller has good title and is therefore able to convey good title to the buyer. There are a couple of ways that can happen. Sometimes the seller gives what's called an abstract of title, and that's a book that's the history of the title to the property going all the way back to the Treaty with Spain. Every transaction that's ever happened that affected title of this piece of property is all shown in a book. And the buyer examines it and makes sure that all the mortgages have been paid off. In each case, this seller conveyed to this guy, to this guy, to this guy. There are no outstanding interests or people from whom deeds need to be obtained. The other way is title insurance. And title insurance is where a insurance company guarantees to the buyer that it has examined the title and that the buyer is getting good title. And that, of course, like any insurance, has a premium to be paid. The buyer pays a premium to the title insurance company, who guarantees that it has examined title and that the buyer is getting good title. And if title fails later, title company pays for it. Title company pays the defendant. Title company will refund the buyer's money. It's an insurance policy to protect the buyer against a future title claim. But in some way or another, buyer, unless he's a total idiot, has to satisfy himself that he's really dealing with the owner of the property and that getting a deed from whoever it is he's dealing with is going to transfer good, clear, as we've talked about, fee simple title to the property. Yes, ma'am.
Is that what's called errors and omission?
No.
No?
No. Errors and omissions policies are something totally different.
Oh.
Errors and omissions are if a title company or a title agent makes a mistake.
Oh.
But it's not the policy itself that guarantees the ownership of the property. That's called title insurance.
Okay.
Errors and omissions is, did the title company screw up and forget to prorate the taxes? Did they forget to record your deed?
And what happens if that title company is closed now? Who do you go after?
If the title company closes down, you're not relying on the title agency. You're relying on the insurance policy, on the underwriter. The underwriters are huge insurance companies, and hopefully they're still in business. Now, if they go out of business, well, like any policy, anytime you got an insurance policy, if somebody goes out of business and can't pay a claim when the time comes, well, stuff happens. But it's not just the title agency. The E&O policy protects you against errors made by the agent. The title policy is issued on the underwriter, which is the actual title insurer, which is a big insurance company in Connecticut or Delaware or Texas or somewhere that is the underwriter. Okay, like Lloyd's of London, the company that's actually providing the insurance coverage. Okay, now the sales contractor is going to talk about what form of deed the seller is going to give at the closing. We're going to talk about the different forms of deeds, but in some forms of deeds, the seller guarantees the title is good. Now that's not enough all by itself. You still want to have checked to make sure for yourself that you, the buyer, are satisfied the title is good. But in some types of deeds, the seller guarantees the title. He warrants that the title is good. In other types of deeds, the seller doesn't. It's kind of like an as-is thing. The seller says, I'll give you whatever title I got, but I'm not saying that's any good or not. Again, double the reason that the buyer needs to have inspected the title and make sure. Normally, there will be property inspections. Our contract addressed those, as you know. Sometimes they are, well, of course, they're inspecting things in the improvements to see what condition the improvements are in. Roof inspection, termite inspection, plumbing, electric, seawall, all things to make sure that the improvements are in good condition, have been well maintained, will function well for the buyer. There are two types of remedies under inspections. One, as we talked about, is the buyer does his inspections, and if he's not happy, he cancels, deals off. Seller's made no guarantee that he'll fix anything. Seller's made no guarantee as to the condition of the property, of the improvements whatsoever. Buyer is to check it out, cancel, or close. Under the other types of inspection clauses, sellers guarantee that they will repair. Seller will say, if your roofer finds a problem, I'll get the roof fixed. If your plumber says the plumbing is bad, I'll get it fixed prior to closing. And then the seller, at the seller's expense, gets these things fixed. And as we saw under this clause that we saw in our addendum, normally the seller, to protect himself though, puts, I'll pay up to X amount of dollars to get it fixed. If in a $100,000 deal, the buyer had a roof inspection that said that you need a $30,000 new roof, the seller might want to cancel. He might not want to pay $30,000 and still just get $100 at the closing. So sellers who do say they're going to repair normally cap their exposure, the amount of responsibility that they will assume to pay for repairs. All the things that we've talked about so far are factors in any residential or commercial deal. In a residential deal, there is one other thing that a buyer might do to protect himself against problems with the improvements. And that's the purchase of a home warranty plan. where a third-party insurance company agrees to fix for a certain period of time whatever goes wrong.
Who buys that?
That is negotiable as to who's going to pay for it.
Okay.
Sometimes the sales contract says closing is conditioned upon buyer's ability to obtain a home warranty plan at buyer's expense, because these home warranty places come check out the property to decide whether they want to insure it or not. If it's in too bad a shape, they're not going to insure it. So, and in some cases, the contract provides that the buyer won't inspect the property at all, but seller will furnish at seller's expense this home warranty plan, so the buyer knows for the term of the plan, for the first 3 years or 5 years, whatever goes wrong, the insurance company will get it fixed.
Oh, okay.
So the buyer doesn't really need to inspect, because the buyer knows he's not going to incur any expense of repair during whatever period the plan is that they've negotiated. These plans are available for single-family residences, but nothing else. So that's why you won't see a home warranty plan, named of course a home warranty plan, in an apartment building or an office building or a shopping center or anything like that. There's no such thing as a warranty plan for commercial buildings. Okay. We talked about earnest money, deposit money. It's not required for consideration, but it's a good idea for a couple of reasons. To show the buyer's good faith that he really means it, that he'll put his money where his mouth is, he really does intend to buy. To show that the buyer has some money, because if he can't come up with a deposit, how seriously are you going to take him that he can come up with a couple $100,000 or a month? And lastly, as a liquidated damage forfeitable amount, to give the seller something in case the buyer doesn't close. The seller's taken the property off the market for 2 months. Maybe he's missed some other deals. He wants to get something out of this deal if it doesn't close. Now we're assuming, of course, when we talk about the deposit being forfeited by the buyer to the seller, that there were no contingencies that failed. These contingencies, like whether or not the house passes inspections, whether or not the buyer could get a mortgage, well, in those cases, if those things don't work out, the buyer is going to get his deposit back. Because the contingency failed, the deal is off, the buyer gets his deposit back. Seller's not going to get the liquidated damage buyer's deposit amount. That's only if the buyer defaults. Meaning, all the contingencies, if there were any, are satisfied, and it's time to close, and then the buyer didn't close. Okay. Signing the contract, that's my third of the big three. Get it signed right. Get it signed by a proper corporate or entity officer, based on whatever type of entity you have, whoever has the authority to bind that type of entity. Get all of your seller's signatures on there. And of course, if the contract names 2 or 3 buyers, get them all on there too. But that's not as big a factor. Usually the buyers are all going to sign. The question when you go take it to the seller to get the seller's signature, make sure you get somebody binding. The materials talk about attestation and acknowledgement. These are concepts we're going to talk about in a deed, but you don't do them in a sales contract. Attestation is simply witnesses. Does a sales contract need to be witnessed? The answer is no.
Do we need to know that now?
I'm sorry?
Do we need to know that now or no? Do we need to know that? The witnesses don't...
You don't need witnesses on a sales contract. Right, not at all. No. For a sales contract, you don't need witnesses, and acknowledgement means notary. Acknowledgement is where a notary says, yeah, I saw him sign it, and I know he's who he says he is, and I notarize his signature. That's called acknowledgement. That likewise is real important in a deed, is not done with a sales contract. The materials talk about in some jurisdictions it may be done, but it's not done in Florida. You don't get sales contracts witnessed, you don't get them notarized, either one. And lastly, in the text, talks about closing. Told you a little bit about what's going to happen in closing, and we talked about that too, and we're going to have a whole chapter about closing. Most importantly, it says when is closing going to take place. That's hugely important for the planning of both of the parties. Usually talks about where. Parties don't usually get in a fight over that though. Usually, customarily, the buyer picks where it's going to close because he picks a title company that's going to close it, and it's usually held in the title company's office. Remember what's going to happen at the closing, and your contract will talk about it. But that the seller's going to hand over a deed, the seller's going to sign, usually sign there, may have signed it in advance, but usually sign it at the closing, and hand over the deed to the buyer. Buyer going to pay the balance of the purchase price to the seller. Parties are going to sign a closing statement. We're going to have a chapter on that too. And it's going to adjust all of the items we talked about, the expenses and income from the property, and all going to get adjusted at the closing. And those matters are all going to be talked about a little bit in the sales contract to tell the parties what's coming at closing, who's going to pay what closing expenses, and what's going to happen. Okay. I'm going to say for the last time, then, the big three that we've talked about to get right. The names of the parties, the proper description of the property, and the signatures of the parties, binding signatures. For the names of the parties, we're going to get them from the property appraiser or from the deed. The signatures we're going to get from the Secretary of State telling us who the proper corporate officers are, or the owners of record that you've seen from the property appraiser's website again. Remember to get somebody's spouse to sign, because it might be homestead. If it's homestead, the spouse is going to have to sign the deed, and you can't make the spouse sign the deed unless the spouse has signed the contract. So get spouses on there, unless you know it's commercial property and it's not homestead. Of course, if the spouse is an owner, of course you're going to get that spouse to sign, because you're going to get all the owners to sign, but we're talking about who else. And a description of the property, we said you'll get from the property appraiser or from a deed. And the reason you want to get all three of these right is so the court will enforce the contract. Because if the court won't enforce your contract, you're wasting your time. You're hoping the court would give you specific performance if the other side fails to perform, but the court is not going to do that if the court decides your contract is not enforceable. And if you didn't get those three things right, the court's not going to enforce it. Finally, if by any chance you don't understand what you're signing, or you're nervous, the best time to get a lawyer is right before you sign the sales contract, not right after. Right after, the lawyer can make sure for you that everything in the contract is carried out and is lived up to. But the lawyer can't change the deal for you and can't improve the deal for you. We used to say that the most important function a lawyer can perform is to help you improve the sales contract before it gets signed, because after that, you've already made your whole deal. And all the lawyer can make sure you do is get what you're entitled to under the contract, which may not be everything you wanted to have. So if you've got any question at all, either get a lawyer to look at it before you sign it, or put a clause in it like those we saw at the end of the addendum where it says, for the next 5 days, my lawyer gets to review this. So it can happen, your lawyer's review can happen after you sign it, if you've got a contingency in there that says, contingent on my lawyer's approval. But if you don't, and you take it to your lawyer the next day and say, what do you think? Can you get me out of this? The answer is probably no. Okay. That's it for sales contracts, unless y'all have any questions. All righty. Now the materials organized this section, this 3-chapter section is called the purchase agreement. And the purchase agreement's first 2 sections were, of course, about contracts and then about real estate contracts. But the third thing that the book brings in this section now of talking about the contract is now real estate brokerage. And the reason is because the odds are very good that a real estate broker is going to be involved in your real estate transaction. It's good. Not always, but most of the time. I know at least one of you was a licensed real estate salesman. Others have worked in the area. I know you got some exposure to this. We're not going to talk about licensing at all, or except to say that later we're going to talk about that licensing is required and who's required to get a license. But not all the requirements and testing and educational and CLE that we call it, continuing education, that you have to do to keep your license up. That's not what this chapter is about. What this chapter is about is the function of a real estate broker in a real estate transaction. And a lot of that function of the real estate broker involves the sales contract that we talked about, because that's usually who's getting it filled out, or who's getting it signed, or who's walking it back and forth between the parties or negotiating it. There's an incredible amount of material here in this chapter. I want to try to teach you what I think you need to know about brokers in order to deal with them. But by no means is our topic how to be a real estate broker. That's not what this course is about. Obviously, this course is what you need to know about real estate law in order to function in the commercial real estate community, but it's not how to be a broker. But you're going to have to deal with brokers, and you're going to have to know what the terms mean in their business, because you are going to deal with them for sure if you're going to deal in the purchase and sale of real estate. In order to understand real estate brokerage, you need to understand the concept of agency. Agency in the law is where a principal appoints an agent to act on behalf of the principal in dealing with third parties. We all know what an agent is. Sports stars have agents. Movie actor stars have agents. People that negotiate deals for them, who negotiate with third parties on behalf of the principal. The principal obviously is the baseball player or the movie actor. The agent is the person who negotiates their deals. The legal relationship of those parties to each other is called agency. As that relates to real estate all states require that an agent be licensed. And we're talking now about brokers, not yet really getting into salesmen, which will come later. But as the law of agency is involved, it's the agent that has to be licensed, certainly not the principal. Know, if you will, though, that although agents normally can contract for parties in an agency relationship, that does not apply in real estate. Real estate brokers don't sign sales contracts. That's why we talked about making sure you got the right seller signing your contract, not signed by the broker, signed by the agent. I'm sorry, signed by the principal, signed by the owner, the seller, the real owner, not the broker. I'll talk for a moment about powers of attorney, because a power of attorney is a concept you're probably familiar with, and it's agency. That is agency, same thing. You got a principal and you've got an agent. Now, normally under a power of attorney, the agent can sign. That's normally what a power of attorney does, is give an agent the power to sign for a principal, except our agency agreements in real estate for a real estate broker. As to brokerage, don't normally give the broker the power to sign the contract. Okay. Now, we've said within that principal-agent relationship, the agent is the broker. So, a broker in a real estate concept, or context, is an agent who is appointed in an agency agreement to bring parties together and negotiate the sale of real estate for a fee. Brings the parties together, negotiates for the sale of real estate, gets paid a fee. Fee is called a commission. In a real estate context, the broker's fee is called a commission. And the broker is the agent in the agency relationship between the seller, the principal, and the agent, the broker. Okay, the materials talk at some length about the broker being an independent contractor. I don't want you to focus on that distinction. That's a very complicated legal concept of who's an independent contractor and who's an employee. And there are lots of tests and lots of litigation. I don't think you need to spend your time worrying about whether a broker is or is not an independent contractor. Now, the agreement where an owner, the principal, hires a broker, an agent, is called a listing. We said the concept here is agency. An agency is created by an agreement. In our context of real estate, it's called a listing agreement. And that's where a seller authorizes a broker to find him a buyer for a piece of property upon specific terms, and the broker will be paid a fee, a commission, if the broker is successful. Now, you pretty well know that. That's you can call it the employment contract. It's the contract between, we talked about contract law, it's the contract between the owner and the broker for the broker to sell the property for a fee upon certain specified terms. Okay. There are three types of listings, three types of agency agreements that a real estate owner can have with a broker to sell his property. I'm going to change the order of the book because I think they make more sense in this different order that I'm going to give you. The first I call the open listing. That's the name the book uses too, but I think it should be first, and here's why. Under an open listing, the owner is saying to the broker, I'll pay you a commission if you sell my property, but I reserve the right to sell it, or I reserve the right to have other brokers sell it too. It is the least restrictive on the seller. It is the least attractive to a broker, because all a broker knows there is if he gets the property sold, he gets paid. But there might be lots of other brokers out there with an open listing too, and they might sell it first, or the seller might just sell it himself. So an open listing is the least restrictive for the seller. The seller can still get a lot of other brokers if he wants to, or sell it himself. And that's an open listing, which basically means it's wide open. The next level up for the broker is called the exclusive agency. And that's where the seller says, you are the only broker that I'm going to hire. Under our open listing, the seller can hire 10 brokers. Whichever one sold it is the one who got paid. Under exclusive agency, the seller says to the broker, you are the only broker that I'm going to sign a listing with. But I, the seller, reserve the right to sell it myself. And if I sell it, there's not going to be any commission. But if you sell it, of course I'll pay you a commission. And I'm not going to get any other, I'm not going to sign up with any other broker. That's an exclusive agency. Term makes sense again. It's the exclusive agent. There will be no other agent. There will be no other broker hired. All right. The next and other last final type of listing is called the exclusive right to sell. Now this is what a broker really wants. And it also is what the name says, if you think about it. It's the exclusive right to sell the property, period. Not only are you the only broker that I'll hire, but you're the only person that has a right to sell the property at all. I, the seller, will not sell it myself. Or, if I do sell it myself, I'll still pay you commission. In other words, the broker knows that there'll be no other broker and the seller won't be out there cutting deals and selling it without paying him. If the property is sold during the period of the listing, of course, and we'll talk about that, the broker's going to get a commission. Yes, Lauren?
On the exclusive agency, the broker is the only one that can sell it, but then the owner still reserves the right to sell himself?
Exactly. That's the difference. That's the difference. Under exclusive right to sell, the term is exactly what it says. The broker has the sole right to sell the property, and therefore, if it sells, is going to get a commission. Okay, listing agreements have a term, of course, under this exclusive right to sell, obviously, if you say for the next 6 months, I agree, I won't sell it either, I'll only let you sell it to broker. You want to have a period of time. You don't want these, nobody would want these to run forever. I think the real estate licensing agencies require listing agreements to have a specific term in them. In my experience, usually the broker asks for a year because the broker's going to incur advertising expenses, listing costs with a listing service, which we'll talk about. But the broker is going to incur costs. So the longer the listing agreement is, the more likely the broker has an opportunity to sell the property and recoup those costs. And therefore, the stronger the listing, in other words, the exclusive right to sell, or at least the exclusive agency, the broker knows that if he spends the money, he's more likely to have the sale and therefore get to recover those costs. Okay. There's something called a multiple listing service. It's called the MLS. The materials, as far as I'm concerned, define it a little bit wrong in terms of my understanding of what the MLS does and what its legal function is. But what it basically is a listing service where you can go find all properties that are for sale by all the different brokers. So that every broker and even owners can go to these listing services and find everything is for sale and find information about properties and decide what they want to see. Now, the book says that brokers are actually sharing their exclusive listings. I don't agree with that. They still are the listing broker. What they're doing is publicizing their listings to give other brokers access to their listings to make it more likely that the property will get sold. Now, of course, if other brokers get involved, they're going to have to share the commissions with the other brokers, but it's to create more exposure of the listings. But they're not sharing their exclusive listing in the sense of all other brokers become listing brokers too. They're not. They're just sharing knowledge of the listings so that information is more freely available to increase the likelihood they're going to have a sale. But it, of course, means that they'll have to share the commission with another broker if another broker gets involved through the MLS. The materials, the book next talks about the concept of authority, and I really don't want to get into that because it likewise is a whole area of agency law that is all about the authority that is expressly given to the agent by the listing agreement, or authority that is implied by law. And there's lots of litigation over this stuff. I don't think it's important to understand the legal distinctions between express authority and implied authority in terms of your dealings with a broker. I don't think it's going to become a factor, and I don't think you should trouble yourself trying to learn that. You do need, though, to understand what the broker's duties are. Brokers, we're going to talk, as you know, we're talking about the broker that's being hired by the seller, the owner, that's the seller. And we're going to talk about the broker's duties to his client, the seller, and then we'll talk a little bit in a minute about the broker's duties to the buyer, who is not his client and with whom he doesn't have a listing agreement. The duty of a broker to the seller is encompassed by one short phrase that everybody acknowledges, but it means a lot of things. That duty is called good faith and loyalty. The duty of the seller's broker to the seller is to use good faith and loyalty in advancing the best interests of the seller in the service of the listing agreement. Now, that duty of good faith and loyalty means a few things. It means full disclosure. The broker is to disclose to the seller everything that goes on that happens regarding the sale of a piece of property. He's to obey instructions from the owner. He's to account to the owner for any funds that he may receive. And lastly, he has to act reasonably and carefully. These are the duties of the broker to his client, the seller that owns the property. Here's what I want you to be aware of and think about. It's very easy when you're the buyer and you're looking at a piece of property being shown to you by the listing broker to start feeling real cozy with the broker and feeling like he's your buddy, and he's your friend. And you want to be careful because he doesn't work for you. He works for the seller. You'll never meet the seller though. The only person you're ever going to meet is the broker. At the property, you're going to look at the property together with a broker, and they're going to talk about all the fun, wonderful things you could do with it and decorate it and all the fun you'll have here, and this is all great. And then you'll say something really stupid to the seller, to the broker, like, all right, we'll offer $250,000. We're willing to pay more, but let's offer him $250,000. Now that willing to pay more, the broker is obligated by law to tell that to his client. You may say, don't tell him we're willing to pay more, but we really like this. Let's offer $250,000, but we'd be willing to go to $300,000, but let's offer $250,000. Your buddy, the broker, is obligated by law to tell that to his client, the seller. And what do you think your price is going to be? Your price is going to be $300,000. Seller's going to refuse your offer at $250,000. He's going to counter at $300,000 or $3 1/4, so you end up at $300,000. Point is, as a buyer, and you might be in this capacity as a buyer of a piece of property dealing with the seller's broker, remember who he works for, who his fiduciary duty is to, who he has to fully disclose to, who he's looking out for, and it's not you. It's the seller. Now, although that seller's broker, his primary duties are to his client, the seller, he has a few duties also to the buyer, who is not his client and who does not have a listing agreement with him. He's got to tell the truth. No misrepresentation, no fraud. If he misrepresents something or outright lies about something, he can be sued for damages by the buyer. So, although he doesn't have a contract, doesn't have a listing agreement with the buyer, he's got to be honest and straightforward with the buyer. The law also says that he may not conceal any defects in the property. He's not necessarily obligated to say, hey, look over here, there's a crack in the wall. But he can't conceal them either. He can't hang a picture in front of a crack on the wall merely to cover up a crack. So, the broker, when you're the buyer, is obligated to at least tell you the truth to the questions you answer, not make any mistaken misrepresentation, or not outright lie, which is actionable as fraud, and not to conceal any defects. Okay. Now, up until now, we've been talking about the broker as the agent of the seller, as the agent solely of the seller, the owner of the property, and his obligations under his listing agreement to his client, the owner of the seller. But there's several other types of capacities that a broker can enter into. The broker can be hired by the buyer and can be a buyer's broker. And what the buyer's hiring him to do is saying, find me a piece of property upon the following terms for me to buy, and I, the buyer, will pay you a commission. And that's a buyer's broker. In which case, all of the good faith and loyalty obligations that we talked about before, well, now the broker's good faith and loyalty obligations are to his client, the buyer, because he's a buyer's broker, and the buyer hired him. And of course, the shoe's on the other foot when we talked about being careful. If you're the seller, what you tell a buyer's broker, because it's going right back to the buyer. So understand that normally the broker works for the seller, but brokers can be hired by the buyer, in which case they're a buyer's broker. Or there's a relatively new concept where the broker can work for both parties. And that's called a dual agency. Dual, D-U-A-L, agency. And that's a transaction in which the agent represents both parties, the buyer and the seller. Sounds kind of like an oxymoron, like you couldn't possibly have good faith and loyalty to both parties. And you probably can't. But it's allowed now. And it's allowed, and a broker can be paid commissions by both parties, and has duties to both parties. But he's got to disclose to both that he's acting as a dual agent, and both parties have to give their written consent to the broker being a dual agent and representing both buyer and seller at the same time. There's one other capacity a broker can fill, and I don't have a good grip on this one, and it's called a transaction broker. And that's where a broker is hired for a specific transaction only. Not, in other words, not sell my property to whoever you can sell it to, or find me whatever piece of property you can. This is where a broker gets hired for a specific transaction only between identified parties with an identified piece of property. And that's called a transaction broker. And his sole obligation is to see that the deal is concluded, but of course that's every broker's obligation. This is really, really rare. But this is where the parties already know that they want to make a deal. And they already know, of course, what property they're dealing with, and they bring in a broker strictly for the purpose of that one transaction. Okay, so those are the different capacities a broker can hold. Normally it's a seller's broker, occasionally a buyer's broker, sometimes a dual broker or a dual agency, and then very rarely a transaction broker. Let's talk about the broker's commission. Broker's commission is his fee. There are often disputes over the payment of a broker's commission. Disputes normally arise over the following questions. Has the broker done the job that he or she was hired to do? And the listing agreement will normally specify what the broker was hired to do. And then, when has that broker's job been accomplished so as to entitle him or her to a commission? Those are what parties usually fight over and disagree over. What was the job and has he really done it? And secondly, when is it actually accomplished such that he's entitled to a commission? Now, the first test of has the broker actually done the job he was hired to do usually involves two concepts. According to the court's tests in the huge amount of litigation over the subject. The first one is called the procuring cause. Was the broker the procuring cause of the sale? And that means, was the broker the primary and proximate cause of the sale taking place? Did he bring it about? Did he do it? Did he get it done? Did he make it happen? Was he the procuring cause of the sale, primary cause of the sale? And secondly, the second test is, did the broker produce a ready, willing, and able buyer? Now, that means, did the broker find a buyer who was able to perform his agreement to close the purchase of the property? Now, these issues are not going to affect you a lot when you're the buyer, but they're going to affect you an awful lot if you're a seller and you sign a listing agreement for the broker to sell your property. You're going to be real interested in, when am I going to owe him a commission? When has he done his job? And what kind of buyer has he brought me here? In order to determine whether the broker ought to be paid. And that's where these disputes arise between the seller, who's not happy with the deal because it didn't close, and the broker saying, I did what I was supposed to do. I brought the parties together, and I brought you a buyer who was capable of performing. And for some other reason, the deal didn't close. That second test on a ready, willing, and able buyer, the courts have said that that buyer must be able, must be of the following, one of the following conditions. Any one. Either the buyer had the cash ready to close, or the buyer had good, strong credit rating so that he could borrow the money, and had sufficient other cash to close the deal. Or thirdly, this is a buyer who already has a commitment for a loan. And there's some of those out there. People get pre-qualified now. People go to lenders and get approved for a $300,000 loan. and they already have a commitment. It says, once you pick out a piece of property, we, the lender, will loan you the money so you can buy it. So a ready, willing, and able buyer has got to be one of those three things. Buyer's got the money, or buyer's got good credit and the rest of the money, or the buyer's already got a loan commitment. Okay, so those things are the first part of the test of, has the broker done the job he was hired to do? Was he the cause of the sale, and did he bring a ready, willing, and able buyer? And secondly, is a question of, when is the commission actually earned? And this is very interesting because brokers' commissions are almost always paid at the closing. But that's because their agreement provides that their commission is not paid until the closing. But they may have done their job long before the closing. In most states, the courts say that the broker has earned his commission when he's procured the buyer, who is a ready, willing, and able buyer, and the buyer has submitted an offer on the seller's terms. Even though the listing agreement might say the commission itself is not payable until the closing, the broker's commission has been earned when he's found the buyer who's ready, willing, and able, and the buyer has submitted an offer matching the seller's terms in the listing agreement. Now here's what I want you to be aware of, and that's the law in Florida too. If you hire a broker to bring you a buyer upon certain terms, I want $300,000, I want it to be all cash, and I want a closing within 60 days. If the broker brings you a willing and able buyer who agrees and submits a contract that he'll pay $300,000, all cash, and close in 60 days, at that time you, the seller, are obligated for a commission, whether or not the buyer closes. You're obligated for a commission because the broker has done his job. Find me a ready, willing, and able buyer who can meet my terms. At that point, the commission is deemed earned by the courts. Understand that if the broker brings you a buyer on those terms and you refuse to sign the contract as a seller, the broker can then sue you for a commission right then. He's done his job. Even though your listing agreement probably says he won't get paid his commission until the closing. That's merely a when is it paid, not when is it earned. It's earned when the broker brings you the buyer who can close, and the buyer's offering to pay on the terms that you put in the listing agreement is what you want. Okay. How does an agency agreement get terminated? Kind of like we talked about, a contract can be terminated either by act of the parties or by operational law. Because it is a contract. It's a listing contract, but it's an agreement, it's a contract. And like other contracts, it can be terminated by acts of the parties. The parties can just say, sign an agreement, we don't want to have the listing and be in effect any longer. Now, however, listing agreement may have a period of time in it that says it can't be canceled for a certain period. So although the parties may terminate the agreement if they want to. At any time they want to, they both want to. Sometimes a party can't terminate because a period of time is not run during which it said that the agreement could not be canceled. Or agreements can be terminated, as we talked about, by operation of law. And that means not just a new law is passed, but by an outside happening that is not an action of the parties. A death of one of the parties, the broker loses his license, the property is destroyed. Outside of an action of one of the parties, a listing agreement can be terminated by certain events. Okay, materials now talk a little bit about licensing. They talk about a real estate sales associate. An associate is a person who's employed by a real estate broker and under the broker's direction lists and sells real estate. Normally, most of the people you deal with are going to be associates. You're not going to be the broker. A seller, owner who wants to sell a piece of property hires a broker, signs a listing agreement with a broker. The broker has hired sales associates to work for him who, under his direction, help sell the real estate, show it, take buyers through it, prepare contracts, submit contracts. Most of the work is done by real estate associates. They are not the person that signed the listing agreement with the owner. That's the broker. They work for the broker, they're employees of the broker, and they do most of the work. That's called an associate. Now, every state, including Florida, all 50 states have licensing laws that require that anybody who sells real estate has to have a license. We have FREC in Florida, the Florida Real Estate Commission. It's empowered by the legislature to regulate and license persons who sell real estate. Both sales associates and brokers are licensed. The licensing obligations for brokers are much stricter than they are for sales associates. And you have to have been a licensed sales associate for a certain period of time, working for a broker, before you're allowed to apply and try to become a broker. In both cases, you have state exams, you have background checks, you have fees, you have continuing education requirements, but they are much more stringent for a broker who is the person who actually takes listings from the seller than they are for associates who work for a broker under the supervision of a broker. They each have licenses, but they're different kinds of licenses. Broker's license and salesman's license. Now, I want to talk about a concept that brokers run into, and I want you to be aware of it, because if you don't already, it's very possible that someday you'll have a real estate license. As a salesman, maybe not as a broker, but as a salesman, and the reason you might is, if you go to work for a developer that sells real estate, you're going to have to get a license. If you develop real estate and your firm sells it yourselves, sells your own developed real estate, you're going to have a sales staff, and the people on that sales staff are going to have licenses. Any Body acting in the sale of real estate is prohibited from practicing law. And that's the concept I want to talk about. It's called the unauthorized practice of law or the unlicensed practice of law. And in either case, people talk about it as UPL, unauthorized or unlicensed practice of law. And the reason this is a factor is because when you're acting in the sale of real estate, you're going to get asked lots of legal questions by buyers, by sellers. They're naturally going to ask you as a real estate professional questions that involve giving legal advice. And you may be asked to draft documents. That is the drafting of legal documents. And in all those cases, you may or may not be practicing law, and your practice of law may or may not be unauthorized, or it might be authorized. So we're going to talk about the why and the when. And the reason this is important is because the unauthorized practice of law in Florida is a third-degree felony. And it is vigorously prosecuted by the Florida Bar, because the Florida Bar regulates lawyers, but the Florida Bar also works heavily in the prosecution of parties that it deems are practicing law without a law license. So it pushes states' attorneys to prosecute people for the third-degree felony of the unlicensed or unauthorized practice of law. And if I didn't say this already, 5-year prison sentence for the unauthorized practice of law. So this is serious stuff that you don't want to stumble over once you are in the business of selling real estate. And if you're in the business of developing real estate, you very often are going to be in the business of selling. Now, unfortunately, we don't have a nice, clear, statutory definition of what is the practice of law. In fact, quite to the contrary, the Florida Supreme Court has said that it can't give a precise definition of exactly what is practicing law. In fact, in a famous 1962 case, the Florida Supreme Court said it was impossible to define the practice of law, which sounds a little bit scary, that you can be prosecuted for a third-degree felony for a crime that the court can't even define what is the crime. But it's going to give us some tests. Here's what the court has said is the test. If the giving of the advice and the performance of the services affect important rights of a person, and if the reasonable protection of the rights and property of those being advised and those being served requires that the persons giving such advice possess legal skill and knowledge of the law greater than that possessed by the average citizen, then in that case, the giving of such advice and the performance of such services by one for another as a course of conduct constitutes the practice of law. Now that's about as vague and circular as I think you could get.
Can you repeat that?
I'm sorry?
Can you please repeat it?
Well, let me just tell you what it boils down to.
Okay. Better.
So legal scholars have said that there's a two-part test here. And the two-part test is of whether you're committing the unauthorized practice of law, is whether or not what you've done is the practice of law, that's what that circular definition was all about. What is the practice of law? But then secondly, is that practice authorized? And only if it's unauthorized is it going to be a crime. What the court said, and let me try to boil that down in that circular definition. They've said that if the matter on which advice is given requires the person giving the advice to have greater legal skill and knowledge of the law than the average person has, then the advice or the service is the practice of law. So, giving advice that a layman could give is not practicing law. But giving advice about a legal matter that only a person with special legal skills would have, beyond the average citizen, then that in fact is the practice of law. So the court has said that's what practicing law is, but that the crime of the unauthorized practice of law is only if you're doing it in an area that the court has said that you have to have a law license in order to do. The court is saying that practicing law is one thing. Unlicensed practice of law is when the type of law that you were practicing required a legal license. Then it's the unauthorized practice of law. And they're going to give some examples, and we're going to make some sense out of it. Laura, to try to answer the one other thing the court has said in a later case in 1980 is said that the single most important concern in the courts defining and regulating the practice law is to protect the public from incompetent, unethical, and irresponsible representation. So, once again, they haven't outlined exactly what it is, but they've told you that this is how they're going to decide. Is if it was giving advice, for example, on a subject where the court thinks public should be protected from incompetent, unethical legal advice. Now, luckily, what the court has done is gone through a dozen cases over the years and said in each of these cases, this is the practice of law, this isn't the practice of law. And if this is the practice of law, it did or did not require a license. And has come up with exceptions to when a license wasn't required. A law license meaning a law license as a member of the Florida Bar. First and most importantly, in 1950, the Supreme Court said that preparing a real estate contract, the preparation of the contract, is the practice of law. However, if you have a real estate license in Florida, it's okay. It's not a crime. It's not the unlicensed practice of law. If you draft a sales contract and you don't have a law license or a real estate license, then that is the unauthorized practice of law, because drafting a contract is practicing law. But a real estate license is enough.
Quick question.
Yes, sir.
What about if you for sale by owner, where you don't have a real estate license or you don't have a law, but you sell your house and you have to, I'm assuming you're drafting a contract or working with a contract?
Absolutely. You may draft your own contract for the sale of your own property.
then it kind of
Because
combines
you're not
us.
giving advice to any other party, and you're not drafting legal documents for any other party. You're drafting for yourself. Absolutely, you're right, it's a good question. Of course, you can do this for yourself. All these things we talked about, you can represent yourself in court if you want to,
Yeah.
but you can't represent somebody else.
Yep.
So, yeah, what we're talking about here is if you're doing it for somebody else.
Okay.
If you're giving legal advice to somebody else, or if you're drafting a contract for somebody else, yes, that's a practice of law. It's okay if you have a law license, and it's okay if you have a real estate license. But it's not okay if you have neither license to draft a contract for somebody else. Okay, good question. Title insurance companies. Title insurance companies are preparing legal documents. They prepare deeds. Supreme Court has said that the preparation of those documents, those legal documents, is the practice of law. However, a title company can do it if and only if the title company is writing a title insurance policy in the transaction for which it drafted the documents. In other words, title companies can't sit back and prepare deeds of $50 a piece for people for their own deals. But if the title company is issuing a title insurance policy in that transaction, then it can draft documents. Even though it's the practice of law, it can draft documents that are required by the title commitment for it to issue the title insurance policy. Now, the court has gone on to make clear that preparing all these other legal documents are the practice of law, and you gotta have a law license to do it. Preparing deeds, warranty deeds, quitclaim deeds, land trusts, leases, mortgage agreements, all those things are the practice of law, and you gotta have a law license to prepare them. However, as to leases, Supreme Court has said that if the court has approved a form lease and the party filling in the blanks is only filling in the blanks in a court-approved form lease, it's okay if that party has a real estate license. It's still practicing law, but it is not the unlicensed practice of law because the Supreme Court has approved the form. The lease form that we looked at is one of those three leases. So going back and thinking back on that lease form that we talked about, that lease form was approved by the Supreme Court, not prepared by the Supreme Court, but you know, lawyers organization or a realtor's organization, one or the other, prepared that form, made sure that the blanks to be filled in are just informational blanks, had that form approved by the Supreme Court, so that the Supreme Court was saying that even a non-lawyer, that only a lawyer can fill in those blanks for parties, or a licensed realtor can fill in those blanks for parties on one of those three forms. The whole concept here is, and of course, Alex, you're right, of course you could fill in those blanks for your own lease if you're the tenant or the landlord, either one. Of course you can. Of course you can do your own documents. Everybody's allowed to do their own documents for their own transaction in which they're a party. And of course there'll be another party in that transaction. That doesn't mean you're preparing the document for somebody else.
Yeah.
If you're a party to that lease, you're allowed to prepare it, even though there's another party to that lease. But if you're a third party and you're not a party to that lease, you want to prepare that lease for somebody else or fill in the blanks in that form for somebody else, you better either have a law license or a real estate license, or else it's the unlicensed practice of law, and that's a third-degree felony in Florida. Fortunately, the court has gone on with a bunch of other things, has talked about certain things that accountants can do or can't do, or the practice of law. Certain things that architects can do, engineers can do, when they're not practicing law. And that often turns on when they're preparing documents for parties to sign, for third parties to sign. So although regrettably the definition, as we talked about, is vague, at least most of the things that you could ever think of, there's already been a case and the court has already decided whether or not that was the practice of law and whether or not you needed a license in order to do it, or whether a different type of license would suffice. Most of these prosecutions that you'll see for the unauthorized practice of law are these legal form agencies like LegalZoom that you see on TV that says they'll prepare documents for you. But LegalZoom has lawyers on staff. And when it really gets sticky is when paralegals go out and open legal form services where they're preparing legal documents for parties because they know how to do it, but they're not doing it under the supervision of a lawyer. And therefore the bar, of course, for economic and other reasons, is going to try to shut them down. And the Supreme Court will say, without a law license, you can't do it. Not that any of y'all are going to end up opening form supplying firms, but in your capacity of developing real estate for your firm and for what deals that you're in, of course you can prepare all your own documents. It's when you set yourself up as the ability to give advice or to draft those documents for somebody else that you're practicing law without a license. Yes, ma'am.
I've seen some like people that are notaries and they act as paralegals. Like, you know, because they have a notary license, they feel like they can give advice and fill out forms and all that.
It's funny. Notaries are such a strange legal creature. Just about anybody could be a notary that's willing to pay $80 and can get a 4-year license to be a notary. And all that a notary is ever certified is that I saw a certain person sign a document. That's all they are. I know that was the person that the name says it is because I got their ID. So I know I correctly identified the right person and I saw him sign it. And that merely is to guarantee you that somebody named Jim Jones signed that document in front of a notary public. Not necessarily the right Jim Jones, but somebody who can identify themselves as that person. Because historically, notaries used to be able to do